Good evening from Peru. We are pleased to greet you. This is Jorge Isaac Torres Manrique, Dean of the Faculty of Law of the Winston University, Nigeria. First, we would like to thank the Karnavati University of the courtesy of allowing me to share some waves regarding the pending interdisciplinarity agenda of contemporary environmental law. The protection of the environment is almost importance given that the worsening of threats and the new threats have made this clear. In this use, we unravel and develop through its various aspects the challenge that must be taken up in this order to guarantee healthy environment, as well as the realization of the corresponding fundamental rights. The about the way, by the way, situational diagnosis, we have the challenge of achieving a fully inclusive and environmentally sustainable model of developed forces to us to take an in-depth look on development styles in the light of the realists in the 21st century. In this sense, we have uh, the consumer centrism. This is serious threat to the environment as impose a form of behavior aimed at consumes products that harm of the environment. However, it's also detrimental of the economic consumers since it's also basically a matter of systematic and controllable and unnecessary purchase. Next, we have the protection of new subjects of law. This is on the understanding that the legal and mainly constitutional recognition of the new subjects of law it's not sufficient matter, earth, nature, among others. Therefore, we aim the materialization of effective protection of safeguarding. Next, the transfer of environment matters to the courts. We cannot lose sight of the fact that infrequently administrative environmental intervention, either through prevention or sanction, it's not enough to achieve to forces fullest efficiency and effectiveness that environmental care requires. In this sense, in, it's urgent that the respective cases be brought to attention of the judiciary. Next, principle to great speed. However, the observance of the correct environmental protection police also involves considering the principle of celerity as care, since it's a question talking much more than speedy action due to the very important need that this entails to the principle the greatest celerity must be recognized in administrative and judicial courts. Next, new environment principles. The contemporary milestone, typical of the vicissitudes and new technologies and scientific and technological developed, also brights the corresponding adjournment in the different disciplines and science of human knowledge. The fact is that contemporary environmental law it's not sufficient or sufficient to meet to new demands of the concurrent situation. For this reason, we propose as new principles. Uh, First, the environment as Hegel proposed. Second, the preventive principle. Next, the precautory principle. Next, the principle of substance developed. Next, the principle of intergenerational equity. Next, the principle environmental justice. Next, the principle of progressivity. Next, we have about the inclusion of additional rights. For example, the rights of access on information, participation, and justice in environmental matters. Next, we have about the essential interdisciplinary scenario. In this sense, we have the artificial intelligence, the codification, governance, better right to the healthy environmental, training and awareness raising, environmental displaced persons, environmental justice, interdisciplinarity, interinstitutionality, reversing climate change, has hazard polluted westerns, forest lost in the Amazon, and artisanal mining, urgent ratification of the Escazú Agreement, and marine conservation. Finally, in the concluding remarks, we have to say the legal recognition of the environmental principle mentioned above, preferably in the corresponding code, as in some cases its jurisprudential recognition it's not sufficient. It's very urgent and also entails objective, concrete, or timely actions both at administrative and judicial level. This is because there would be no point in their materialization when, in practice, the simple do not turn out to be applied. Consequently, we consider the more than a legislative modification or the aggravation of penalties for crimes against the environment. It's necessary to recognize new environmental legal principles, such as, for example, those developed in this present document. It merits the training and awareness raising of the actors involved in the administration of the environmental justice. Thank you very much for your attention.